Good evening. Welcome to the Instituut. My name is Christoph Paulus and I'm a senior researcher at this institute, the Instituut, a research fellow at the International Center for Counter-Terrorism in The Hague, and the coordinator of the International Humanitarian and Criminal Law Platform, the three organizing institutions of tonight's event. To say a bit more about these three, the T.M.C. Instituut, this year celebrating its 50th anniversary, is a research center for international and European law, and its mission is to contribute to the development of international and European law by conducting independent fundamental research, policy-oriented research, and applied legal research, as well as by initiating and facilitating academic and expert meetings, professional education, and public events with a view to disseminating knowledge of international law and European law. Now, the Institute is dedicated to building a strong research community and creating an environment that facilitates critical constructive reflection. The International Center for Counter-Terrorism, the Hague or ICCT, is an independent think tank and knowledge hub that focuses on information creation, collation and dissemination pertaining to the preventative and international legal aspects of countering terrorism. I would like to thank the ICCT for sponsoring the reception that will follow after the panel discussion. And finally, the International Humanitarian and Criminal Law Platform. Well, this is a research platform on international humanitarian law and criminal law, coordinated by the T.M.C. Instituut, in which several other organizations take part, namely the University of Amsterdam, the Free University of Amsterdam, Leiden University, University of Groningen, the Netherlands Defense Academy, Tilburg University, and last but not least, Maastricht University. Now, tonight's book launch and panel discussion is organized in the context of the Supranational Criminal Lecture Series, SCL Lecture Series, and this series has been initiated and is organized by the Instituut since 2003 in cooperation with the Coalition for the ICC and the Hague Center for International Legal Studies of Leiden University. And I think I've now addressed almost all the different logos that you can see on the slide. I'm very proud to say that we have an excellent panel for you tonight that will reflect on the theme Accountability in the War on Terror. And this theme plays an important role in the book of Helen Duffy, The War on Terror and the Framework of International Law, whose second edition we're launching today. Here you can see the book. First of all, congratulations, Helen, with this remarkable achievement. Now, the idea of tonight is that all three speakers will provide their opinion on this topic, taking into account their professional perspective for 15 minutes each. And I kindly ask the audience to hold their questions until we go into the Q&A session. Now, before I give the floor to the speakers, I would like to briefly introduce them to you. On my direct right and left for you is Norman Farrell, and he's the prosecutor of the Special Tribunal for Lebanon, or STL. And prior to his appointment as STL prosecutor, Mr. Farrell was the deputy prosecutor since 2008 at the International Criminal Tribunal for the former Yugoslavia, or ICTY. He was also the head of the appeal section and a senior appeals counsel from 2002 to 2003 at the ICTR, and he held the same post at the ICTY from 2002 to 2005, and previously was appeals counsel from 1999 to 2002. Now, after being the head of the appeals section, he was appointed principal legal officer at the Office of the Prosecutor from 2005 to 2008, and in addition, he worked for 3.5 years at the International Committee for the Red Cross and advised the organization on international humanitarian law and criminal law. Now, before his involvement in international law, Mr. Farrell prosecuted cases in Canada and argued cases before the Ontario Court of Appeal and the Supreme Court of Canada. Now, sitting next to Mr. Farrell is Larissa van der Herik. She's professor of public international law at Leiden University, program director of the Hague Center for International Legal Studies, and program director of the Advanced LLM program on public international law with specializations in peace, justice and development and international criminal law. She serves as general editor of the Leiden Journal of International Law, and she was the editor-in-chief between 2005 and 2013, and is general annotator for the Dutch general law journal Ars Equi. She also holds the position of vice chair of the Advisory Committee on Public International Law Issues to the Netherlands government, and has advised the government in that capacity, among other things, on drones and cyber warfare. Now, her areas of research and expertise include international peace and security law, with a focus on UN sanctions and terrorism, international criminal law, and particularly the law on genocide and crimes against humanity, the role of domestic courts, and questions of corporate responsibility and natural resources. And her current research focuses on fact-finding in international law, specifically in conflict situations, and the role of commissions of inquiry. And on my far right is Helen Duffy. She's the Director of Human Rights in Practice and Professor Gieske's Chair of International Human Rights and Humanitarian Law at the Grootse Center for International Legal Studies, also of Leiden University. And she currently teaches a course on victims of war in the LLM program, and another course on the international protection on human rights in the advanced master's program. In the academic year 2015-2016, she will teach humanitarian law, human rights, and terrorism as part of the LLM program. And as mentioned, next to being a professor, Helen Duffy runs Human Rights in Practice, which is an international practice based in The Hague that specializes in strategic litigation before regional and international human rights courts and bodies. Prior to establishing her practice in 2011, she served for many years as the legal director of Interrights, and prior positions included legal officer at the ISTY, counsel to Human Rights Watch in New York, legal director of the Center for Human Rights Legal Action in Guatemala, legal advisor to the UK Arms for Iraq inquiry, and legal officer in the UK Government Legal Service. And finally, she's also the author of various publications, including, of course, the book The War on Terror and the Framework of International Law, second edition. I already mentioned it. We are launching tonight. Now, many thanks to all three speakers for being with us. And without further ado, I would like to give the floor to Mr. Farrell.
Thank you very much for the invitation to attend and for the warm introduction. It's a pleasure to be on this accomplished panel, especially with someone that's published a book of over 1,000 pages. My congratulations to Ms. Duffy. It's my understanding that in 66 BC in Rome, Catiline, an ambitious Roman senator, plotted to seize power in Rome. Twice he stood for election as consul, and twice he was defeated at the polls. Following his second defeat, he had Confederates placed at key places throughout Italy, including in the city of Rome itself. The plan was to throw the city into a state of terror, resulting in the murder of the strongly anti-Catiline consul Cicero. Cicero, however, foiled the plot. He arrested a number of key conspirators who were in the city and revealed the plot to the Senate. The Senate, convinced that strong measures were urgently needed, passed what is known as the ultimate decree. That is, a decree that urged the consul to take whatever steps may be needed, quote, whatever steps may be needed for, quote, the safety of the republic. Cicero had the conspirators executed. Strictly speaking, this was illegal. According to the law of Rome at the time, a citizen could never be put to death by authorities without first having a trial. The fact that the Senate had authorized the executions didn't make them legal, for the Senate was neither a legislative or judicial body, but an advisory one. Sounds somewhat familiar to some of the parts of the book that I've read. And though Ms. Duffy's book addresses contemporary events, due to its size, scope, and magnitude, I actually thought I might see some reference to this alleged terrorist act in Rome somewhere in the footnotes. The book, The War on Terror and the Framework of International Law, in its second edition, is a considerable achievement. Though a book of 937 pages, not counting the bibliography, the tables, the list of abbreviations, and the acronyms, it is in fact easy to read and easy to grasp. It presents matters, as I explained to Ms. Duffy, in what I consider actually in a bite-sized manner, so you can absorb and understand each chapter over 1,000 pages. Clarity of writing and organization make it much more manageable than would be expected for a book of this size that covers the numerous interrelated topics that are addressed. On one level, it is a useful primer. It's a useful reference point for understanding, as identified, the applicable international legal framework. It starts with a very helpful introduction in Chapter 1 with the basics, the sources of law, treaties, customary international law, but proceeds to address the complex interplay of international law, international humanitarian law, international human rights law, and criminal law. At another level, it looks at case examples in the practice of states, taking seriously its stated purpose of addressing the practice and implementation, or as has been noted throughout the book, the lack thereof, of the applicable legal framework. In the chapters of the book dealing with terrorism as a crime under international law and the legal framework of a criminal justice approach, Ms. Duffy flags a number of legal issues relevant to the discussion of terrorism. One, early on in her book, is the lack of a customary international law definition of the crime of terrorism, despite the legal development she identifies since the proposed Convention for the Prevention and Punishment of Terrorism in 1937. She argues that despite the lack of a crime under customary international law, there is not a gap in the applicable legal framework. She does note that the appeals chamber of the tribunal of which I work has found that there does in fact exist an international crime of terrorism. In addition to raising the relevant question of whether a crime exists under international law and such implications for the application of the international framework to the events which are described in the book, she also raises the question of the elements and how are they defined. For example, at page 51, she points out that definitions in various conventions are not consistent. They're not even consistent in including a requirement of terrorization at all, or that the requirements differ, or that for many the definition or explanation of what terrorization is not defined. We know, in fact, from the case law of the ICTY and the Special Court for Sierra Leone, of the definition of terrorization under international humanitarian law, particularly Article 51.2 of the Additional Protocol to the Geneva Convention, and the requirement of terrorizing the civilian population. This is pointed out by Ms. Duffy very clearly. But there is less law on what constitutes causing a state of terror. We know that there are a number of domestic jurisdictions, but there isn't any international law or any law from an international hybrid tribunal on what causing a state of terror is. I know we can look to domestic law to see how different states and countries interpret what terrorism is, but I think we also will have the opportunity in the future to look to the STL. As you may be aware, at the Special Tribunal for Lebanon, the accused in the present trial before the trial chamber are alleged to have committed a terrorist attack intended to cause a state of terror by means liable to create a public danger. First of all, the definition and explanation of what causing a state of terror means. Secondly, what it is to create a public danger. And thirdly, applying that law to the facts in the case before the trial chamber will hopefully bring forward some of the elements, at least at a hybrid level, international hybrid tribunal such as the STL, which may be missing at that level. Ms. Duffy also raises relevant principles of criminal law, including the applicable modes of liability. She recognizes, for example, at page 144, in regard to terrorism, that those directly responsible are not only those who implement it, but the network of persons who, for example, contribute, plan, aid, or abet. This is, I think, at least in terms of the prosecution we're carrying out at the STL, somewhat germane, since the person who, one could argue, directly implemented the act and was directly responsible for the alleged act was a suicide bomber who will no longer be subject to criminal prosecutions. And so the actual prosecution investigation focused on those that were involved with the group of persons who both carried out observation, surveillance on Rafi Kariri, and then subsequently were involved in setting up the actual assassination on February 14, 2005. The modes of liability that the Special Tribunal will speak about, which arise from Lebanese law, with the exception of Article 3, are conspiracy, commission, and co-perpetration. Ms. Duffy also interestingly identifies a number of preparatory acts which have now been criminalized. And the fact that the concern she raises is that there's a number of states that suddenly grafted onto their existing laws new laws which then criminalize preparatory acts which were not criminalized before, which raise issues about certainty in the law. Though obviously we are applying simply the law in Lebanon and not a number of the laws that she comments on or criticizes in her book, the Lebanese law does allow for preparatory acts and does allow for such things as conspiracy, organizing, or contribution to a common purpose of a group, which could include contributions prior to. Another point I find interesting as a prosecutor is the ability, as Ms. Duffy states specifically, the ability of the criminal law to deliver on its rule of law promise while meeting certain conditions that respect fundamental principles and rights within the criminal law process. That's a bit of a tension and a dilemma between having the ability to carry out the acts necessary to investigate, having access to places, getting access to evidence, and getting access to witnesses, and doing it in a manner which protects the rights of the accused and those persons who are under investigation. I think she notes quite correctly the challenge of effective criminal investigation and prosecution, not only in respect of terrorism, but international crimes. Helen, being an optimist, points to the fact that the experience of the domestic and international prosecutions of international crimes, particularly organized crimes or mass atrocities, are examples where those challenges have been overcome. I would have to agree. The point is made, and I hope I have it correct, Helen, is that the prosecution of large-scale crimes in accordance with a rule of law framework, including international crimes, is viable. By that, of course, she means that prosecuting terrorist acts in accordance with a rule of law framework is viable. Looking to the work that we do at the STL, though it's a hybrid tribunal applying Lebanese substantive law, we would hope that it would be an example of the viability of investigation and prosecution of not international crimes, those are the crimes prosecuted by the other tribunals, but of, in fact, an alleged terrorist act in a single country under its own domestic law, while following high standards of international justice and the protections of the rights of the accused, though those accused are not present. The investigation and prosecution of such alleged terrorist acts is complex, it's complicated, and it's time-consuming. It is, in fact, more than I found at the other tribunals piecework. It's placing together individual small pieces to build a comprehensive picture. Though I must admit that when I first started working at the other tribunals, the ICTY and the ICTR for a number of years, I found that the investigation and prosecution of those cases were much more complex than any organized crime case I had done or white-collar crime case I had done in my national jurisdiction. I look back on some of those investigations with a little bit of envy. Having a I-4 and S-4 in the country, which will assist you in getting access to documents, or having support from different avenues, are things that are just the nature of the evolving change in investigations and the nature of the crimes that we investigate. For those of you who are involved in those investigations or prosecutions or defending or adjudicating, you'll know, of course, that when you deal with war crimes, for example, you usually have some organized structure of power. It's military or civilian that actually exists in peacetime and is therefore already in existence and accessible. There is a hierarchy, even if it's hard to comprehend, but it's built into most military structures and civilian structures, and it's based on traditional lines of authority. Often the crimes are committed in a territory over which a party has control. So, as an investigator, you start from the investigative hypothesis that at a minimum, that party probably has relevant evidence. When dealing with crimes against humanity, you're looking for a widespread or systematic attack. For widespread attacks, you usually have a greater crime base to work from, and the investigation used this as a starting point. Though terrorist attacks in peacetime could constitute a crime against humanity, as pointed out by Ms. Duffy, there is a large range of attacks that may not. The point is that I hope that some of the questions that are asked, or at least some of the issues that are raised, will be indirectly addressed by the work of the STL. As an example of prosecuting an alleged terrorist act of the nature which is more common to the type of terrorist attacks that we may see than would fit under international humanitarian law or crimes against humanity. And it's my expectation, as has been the case so far, that it would be carried out in conformity with international standards of due process. And even in this in absentia trial proceeds as a full-fledged international trial with the full rights given to the accused. I therefore hope that it will contribute in some small way to the development of a few of the issues identified in the book by Ms. Duffy. That's my link to my work, but it's not relevant necessarily to the book itself. What is the greater contribution to the understanding of the law and to the international framework, its elements, its development, and the issues that are applicable to the law to terrorism is the exceptional book by Ms. Duffy. Congratulations.
Thank you, Ms. Farrell, also for respecting the time limit.
Thank you. I'm very honored, of course, to speak at the launch of one of the most impressive books, I think, that have appeared since 9/11 and now in its second edition. And I find Helen, if I may, Helen's book impressive, not only in size, but most certainly and definitely also in terms of contents and quality. Both the breadth and depth of legal analysis, I think, in this book are exceptional. So 9/11 has surely left its footprint in terms of primary norms of international law, and perhaps most of all the rules on the jus ad bellum, as we are witnessing today with the invocation of the unwilling and unable standard in the context of justifying the resort to the use of force in self-defense against non-state actors, and particularly against ISIS in Syria. We can also see 9/11 footprints in terms of triggering unprecedented creativity at Security Council level, which started to legislate in 2001 with Resolution 1373, and quite recently it engaged anew in such activity with its Resolution 2178 on foreign terrorist fighters. Now, one other concept that has been tested and developed in terrorism and counter-terrorism context, and which is the focus of our discussion tonight, is this concept of accountability, which is inherently a non-legal and perhaps relatively vague notion that can have many meanings. Now, my argument tonight is that with her book, but actually perhaps even more with her personality and her actions and her legal practice, Helen has contributed to shaping this notion of accountability in the terrorism contents, and I think she has given it some true substance in very concrete settings. So in the context of terrorism, the notion of accountability is, I would say, multidimensional and perhaps to some extent chameleonic, as it appears in different shapes and colors in different settings. It is multidimensional in that accountability processes can concern those engaged in terrorism, and there we find, of course, an emphasis on criminal justice processes as the proper response to terrorism, as we have just heard. But we also need to discuss, and this is also what Helen does in her book, accountability in relation to those actors engaged in counter-terrorism. And in that regard, we must look at primary actors, but what we see these days also is an increased focus on accomplices, in particular in the form of state complicity constructions. And we have, of course, the extraordinary rendition case against Poland before the European Court of Human Rights, the Abu Zubaydah case, or I call it Helen's case, where Poland was held to be an accomplice of the CIA and thus having violated the European Convention of Human Rights. And we also see state complicity constructions in the context of drones, and we have had allegations of complicity being made to states sharing their intelligence with the US, which is subsequently used to inform US drone attacks in Pakistan and Yemen. And there have been very concrete allegations against Germany, which even led Germany to restrict the types of information its intelligence agencies can share with their US counterparts. We also have a very recent case in May of this year, the Yemen drones case, which was a case brought by relatives of drone victims in Yemen to a court in Cologne, claiming that Germany in a way shared responsibility for US drone attacks in Yemen against their relatives, because Germany allowed the US to use the Ramstein airbase in different ways in the execution of its drone policy. Now, the case was rejected under the argument that German authorities have very limited influence over foreign US troops, but I think cases such as these are vital examples that illustrate the different ports of entries that exist to operationalize accountability. And perhaps ultimately such cases may lead us to reflect anew on fundamental concepts such as the concept of state complicity and how these concepts are best applied in the context of counterterrorism, where we are faced with long-standing and very harshly and systematically critiqued and exposed policies such as the US drone policy. Now, of course, the risk when we start exploring these, let's say, alternative accountability options is that to some extent they might be seen as letting those principally responsible off the hook, because we have a shift of focus to the periphery, we can say. But I think the better way to see these, what I call multidimensional accountability processes, is to look at them as perhaps a poorly played game of snooker, where one ball can set in motion another ball in quite unexpected ways. And I like to believe in this worldwide web of accountability, which I think fits our pluralistic and disorganized world, which we are now set to live in. And I think that Helen, in her practice and through her book, realizes and explores this multidimensional concept of accountability, where we seek accountability of different actors at different levels, in different fora, and through different legal and non-legal processes, where one process may lead to the other. And I think in this exercise it's important to underline also once more that accountability is not a strictly legal concept, and I do think that we should not discard political and semi-judicial processes, provided that they're genuine, because I think altogether these can all play very important roles. And when we look at jus ad bellum questions today that are quite pertinent, I think we should also look at the role of national parliaments in those decisions to join certain operations, for instance in Syria. And I think if we talk about questions of accountability of governments and their members in their decisions to join those operations, we should not only couch those kinds of discussions in criminal law in criminal responsibility terms. And if we look a bit broader about jus ad bellum and accountability, which I think in the context of counter-terrorism or perhaps beyond also, I think the Dutch inquiry that we had into the war of Iraq, which is the counterpart of the Chilcot inquiry, I think those types of accountability processes are also vital. And in that report, it was stated very clearly that the war in Iraq was an illegal exercise. And violated Article 2.4. So I see accountability as a very pluriform notion, and perhaps more importantly, I also believe that we should see accountability as an ongoing process, and in particular in the context of jus ad bellum, the relevant question not only is whether there is a legal basis for the use of force today, but these requirements of proportionality and necessity must be assessed and reassessed on a regular basis. So I think we should look at accountability as a process and not as one singular moment, and certainly not only as an ex post facto exercise. And perhaps I can refer here to another terrorism expert project to which Helen masterfully participated, which we held in Leiden a few years ago, and which resulted in the Leiden Policy Recommendation on Counter-Terrorism and International Law. And in these recommendations we stated, and they're still quite pertinent today, that, and we stated on various occasions, that states invoking self-defense to justify their resort to use of force must make their case. They must be prepared to make publicly available the information and data that justify their actions and that supports the claims, and they must show that their actions are proportional and necessary. And those justification and explanation processes, I think, are part of accountability processes, and I find it quite important to make that point in the world now. So if we talk about accountability and counterterrorism, there are many more things to say, which of course why we have this big book. I thought there was one more point I want to make in relation to the Security Council and Security Council accountability, and perhaps when we speak about security accountability today and in the context of Syria, the question is whether there can also be accountability for inaction. And in the era of the first edition, we had quite different accountability questions because then we were much more confronted with an overly active Security Council. So I think it's also an interesting shift that even if you focus on the same actor within different periods and different eras, there are different accountability questions. So the accountability question, let's say, of the first edition was personalized in this case of Qadi, and which was this Saudi who was subjected to sanctions imposed by the Security Council. He had been designated as being associated with Al-Qaeda. Now, I don't not necessarily mean to rehash the entire Qadi litigation, but I think it's an interesting example of strategic litigation. I think the two judgments are important to point out. So if we have the first judgment of the European Court of Justice in 2008, where the European Court held that the measures implementing Security Council sanctions were unlawful because they violated fundamental principles of law, and as a consequence, these implementing measures had to be revoked. This was a very powerful judgment, and I think we can make the argument that as a direct consequence of that, let's say, decentralized judgment, the Security Council created the ombudsperson. I think there's really quite a causal link there. And so I think this 2008 judgment shows the power of what I call decentralized judgment of national or regional courts. Now, the second CADI judgment of the European Court of Justice, I think, had quite a different effect. This judgment came out after the Ombudsperson had been created and after, in fact, CADI had been delisted by the Ombudsperson. And so in 2013, the European Court of Justice issued quite a similar judgment as in 2008, but it was quite a different context and it had different effects, because by the time we had the Ombudsperson, but the European Court did not pay any respect to that institution in its judgment. In fact, it ignored it. And I've heavily criticized the European Court for it, not necessarily because I believe that the Ombudsperson is perfect, far from it, but I think that the European Court of Justice decision was untimely and mostly it was unstrategic, because at that point in time we needed to reinforce what we had. We needed to reinforce the Ombudsperson, to institutionalize and further embed this Ombudsperson and not to weaken or to ignore it. And this brings me to my broader point. I believe that if we think in this terms of this idea of a web of accountability and in terms of strategic litigation, it's important that also courts are strategic as well, and they must have an awareness of the greater setting in which they function. So courts must be conscious as well that they are part of a web of accountability, and they should take the possible external effects of their judgments into account. So I look at courts as social actors in a way, and they have different techniques, I think, to do so. It doesn't necessarily mean that they have to fundamentally ignore the legal framework in which they function, but at the very least they can use obiter dicta to express certain ideas. And I think it's up to lawyers such as Helen to inspire the courts to do so. So then I thought I would conclude, if I may, with some words on Helen. So Helen has been teaching in our LM Advanced for some years, besides being a strategic litigator with her own practice. And she has been appointed a professor in the beginning of this year on human rights and international humanitarian law, human rights in practice, in conflict. So she holds the Gieskes chair, as we call it, to its funder. And she's the second holder of this chair. So the first holder of the chair was Lisbeth Zegveld, who brought cases against the Dutch states, civil liability cases for the failure of Dutch within Srebrenica, liability for war crimes in colonial times. So quite unique cases, pushing the law and revisiting standing legal categories and testing them on their justice. Now Helen does the same, strategic litigation, but then on a global level. She brings the cases and she creates the legal arguments that later end up in books, and not only her own. I think she brings the landmark cases. Now, Helen, I want to say this. I believe in extraterritoriality, but perhaps I do not believe in extraterrestriality. So after we have had a chair who explored strategic litigation in the Netherlands, we now have you, who bring the most fascinating case of strategic litigation on a global level. And I think after you have been from the domestic to the global, I don't think there's a level up. And so I speak on behalf of all my gracious colleagues. I'm sure that we're very proud to have you as our colleague, and we're very happy to work together. And I'm sure that I also speak on behalf of Asser if I say that we are very happy to have you part of our Leiden and Hague community. So thank you.
Thanks a lot, Larissa. Helen, the floor is yours.
Thanks very much indeed. If I could just say, first of all, thank you very sincerely to my co-panelists for their really thoughtful words on the book, on me and my upward movements onto another world. But really, your kind, from people I respect as much as both of you, your kind words mean a great deal to me. And thanks also very much to Christoph for his incredibly generous and patient organisation of the event, and to the ICCT for also supporting it. There are a number of people in this room who've actually helped in various ways with the book, and I won't try to pick them out, but I would thank you for your contributions and for taking the time to discuss these issues and to review parts of the book. I do have to say special thank you to Katrina in the first row, however, as she is probably the only person who will ever have read the whole book. And I see today she's got some colour back in her cheeks, so she's recovering, which is great. And finally, of course, thanks to those that endure the terror of people that try to write a book in their spare time alongside other things. So special thanks to the friends and family, especially Fabrizio Lucamaya, and my longest suffering supporter, my mum at the back there, Rosemary. Thank you to all of you very much indeed. So what I want to do is just to make a few comments today. I'm not going to speak about the book because at 1,000 pages I've said too much already, haven't I, on the war on terror. I'm not going to speak to that specifically. But I will offer a few observations from a practitioner's perspective for someone who represents victims of human rights violations, including victims of violations in the course of the war on terror. So I'll offer a few observations on the theme of accountability, and I'll ask the question of how we're faring in practice in terms of accountability in relation to the many very serious violations and crimes that have been committed in the name of security in the context of the war on terror in the past 14 or so years. The first point I think we have to really bear in mind, and Larissa has very eloquently made this point, which is the multidimensional nature of accountability. But it's really important to recall it, and I find this in my work, it's something that I engage with often, is that when we talk about the importance of accountability, we can't just be talking about individual criminal responsibility. That's an essential piece of the puzzle, but it's insufficient in and of itself. Given just as the war on terror was a global and multifaceted operation, I think our approach to accountability has to be similarly global and multifaceted. We have to look at a range of different targets, we might call them, for that accountability. We have to look at the range of states who cooperated in some of the worst elements of violations or criminality in the name of the war on terror. And I'm thinking in particular, if I can take as an example, as it's an issue, as Larissa has said, that I work on often, the Extraordinary Rendition Programme. You know, that, as you know, the global programme of secret detention and torture of persons deemed to be of high value, high intelligence value. And that's been described as involving a global spider's web of criminal complicity, in which many states, I think the last estimate I saw was 57 states, cooperated in different ways to this global programme of torture and secret detention. And I think that raises a number of really interesting questions, as Larissa's alluded to, in terms of complicity. What is the scope? What are the limits of the responsibility of those different states that may have provided intelligence in relation to, that led to the detention and torture of individuals? They may have received intelligence out of that pool of torture, for example. They may have provided, of course, staging and stopover sites, etc. And I think in some of these types of issues, there are areas where the law, I think, is somewhat unclear and indeed may develop and become clarified as a result of war on terror practice. But certainly for accountability, we have to be looking at the accountability, not just in state terms, of course, of the United States, which again, one has an inclination as human rights lawyers sometimes to focus on US accountability. And, you know, as a global programme, we have to be looking at global state accountability. There's also institutional accountability that Larissa's referred to in terms of the role of the United Nations. Though, of course, the role of the Security Council very much continues. You referred to there being a more active era, perhaps, in the early stages. But, of course, with foreign fighters, with the ongoing issues around sanctions, very much still live and ongoing issues about Security Council accountability. How much have we learned from the mistakes of the past? Or to what extent do we continue to make them? And then on another level, just to flag the responsibility, of course, of non-state actors. If we take again the example of the rendition programme, we know that many corporations, many individuals in different capacities, but also many corporate entities were very actively involved in the rendition programme. So interesting, and as we know, difficult issues in practice as to how to hold non-state actors responsible under international law also come into the frame there. And I think there are also many forms of accountability, just as there are many targets for it. And I agree very much with what you said about political accountability. We can have accountability, of course, through truth, through transparency, through acknowledgement, through political accountability in various ways. And of course, also in terms of judicial remedies for victims and individual criminal accountability. And these two last bits are where I'm going to focus most of my remarks today. In these areas, we might say the law is relatively well established, right? We know, for example, that there is the right to remedy and the right to reparation under international law. Is one of the most well-established rules of international law. If there are violations, there's a right to a remedy and to reparation. And that there is individual criminal responsibility for the sort of very serious crimes that we've seen in recent years. And I would just to put out there as a starting point for that discussion, I would certainly say that the crimes of rendition, for example, are crimes that certainly amount to the crime of torture under international law, that so far as they're linked to any genuine armed conflict, which most of them were not, but some of them may have been, they would also amount to war crimes. And also that given their unique systematicity and the organisation of rendition between states and across the globe, I would say that they also constitute crimes against humanity. And many states around the world have jurisdiction over these cases. And I would say indeed that the ICC also has jurisdiction if other states don't step up and assume their responsibility in terms of ensuring individual criminal responsibility. Let me just take a bit of a perspective. I'm here, and my perspective tonight, unlike the prosecutorial and the academic perspective, is the perspective as a human rights practitioner. So maybe I could, as an entry point, just mention some of the facts in relation to one of the cases, the Abu Zubaydah case that Larissa has referred to, and through that ask the question about what accountability looks like in relation to concrete situations such as his. Abu Zubaydah, in brief, was the first victim of extraordinary rendition. We know a great deal about his situation, partly as a result of some of the political accountability processes, such as the Senate Intelligence Committee report that came down in December of last year that has 1,001 references to Abu Zubaydah and makes very clear in some detail the extent of his torture, the specific torture to which he was subject, repeated use of waterboarding up to 83 times in 1 month, detention in coffin-like boxes for a prolonged period of time, walling, smashing his head into walls, sexual violence, rectal feeding, physical, psychological torture, horrific conditions of detention, etc., etc. So we have a lot of detail of the nature of the torture of this individual, and we have it through official documentation from the US and the Senate Intelligence Committee, as well as a number of different sources. Also interesting in terms of the discussion on accountability is the fact that the Senate Intelligence Committee report, and we're talking of course about the 524-page summary of that report because that's all that was disclosed and not the many thousands of further pages that are still secret. But it's notable that in that report it notes the fact that prior to his torture, CIA officials had sought and obtained assurances that he would be held indefinitely for the rest of his life. It quotes a CIA cable which states that, especially in light of the planned psychological pressure techniques to be implemented, we need to get reasonable assurances that Abu Zubaydah will remain in isolation and incommunicado for the remainder of his life. The reply cable is quoted, Abu Zubaydah will never be placed in a situation where he has any significant contact with others or has the opportunity to be released. While it's difficult to discuss specifics at this point, all major players are in concurrence that Abu Zubaydah should remain incommunicado for the remainder of his life. Now, this chilling commitment that was made before he was subject to torture to keep him in incommunicado detention in order to ensure that information related to his torture would never come to light has indeed come true. That is indeed what has happened to Abu Zubaydah, and he remains in incommunicado detention in Guantanamo Bay. He's never been charged with any offence. He's never been subject to any lawful review of the lawfulness of his detention. There's no commitment to try him. There's no commitment to release him. And it appears to be the intention, indeed, as the cable suggested, simply to hold him incommunicado for the remainder of his life. Now, we also know, so we have all of this information about individuals. We also know that information was, false information was provided, information was manipulated in relation to the causes of his detention and indeed in relation to the information that was obtained from him in the course of his detention. We also know, of course, the legal obligations that states are under, and Larissa has referred to the case that we took to the European Court against Poland, because Poland was one of a number of states in which Abu Zubaydah was detained and tortured. And of course, the European Court found that Poland was in violation of its obligations to prevent and protect those against those violations on its territory. But it also found, I think quite interestingly, it refers to society having the right to truth. The right to truth as being something that pertains to the individual, but also to society as a whole. And it refers, of course, to the duty of Poland, like other states, of course, but the duty in Poland to conduct an independent, thorough and effective investigation, to hold to account those responsible, and to provide remedy and reparation. Now, in some ways, that's not that interesting because those obligations are already very well established in international law. It's simply the recognition that they apply in this context. But given that we have all of this information, we have a great deal of evidence in relation to his torture and who was responsible for his torture. We also have clarity in terms of the obligations, and that's been reflected through the work of many other human rights courts and bodies. The question is what has actually happened in terms of accountability in his case or in the case of other rendition victims or other victims indeed of war on terror. And I think the first question, when we're looking at this in terms of individual criminal responsibility but also the individual right to reparation, the first question perhaps that arises is simply the fact that these violations are ongoing. When we talk about accountability, of course we think that looking back that and we have to recall that in situations like his, the violations are ongoing. He is still held in incommunicado detention, a direct result of previous violations in respect of which there's been no accountability. So the first element is cessation of the wrongdoing by the state directly responsible, but also it's a question, I think, of other states assuming their responsibility, particularly those states that contributed to his current situation, assuming their responsibility to try to bring to an end. And I think that's the first element, in a sense, of accountability and reparation is of course, cessation. It's also important in this context to remember that there's no accountability in respect of any wrongs committed by Abu Zubaydah because he hasn't been charged with anything, and therefore he doesn't have the opportunity to refute allegations made against him. I should say in this context he's also subject to a complete communication ban with the outside world, so he's not able to express in any way any opinion, and he can't tell you anything about his torture, he can't tell you any reasons why some of the allegations that have been made very publicly against him may indeed not be justified. So there's no accountability in respect on that side. On the other side, what about the question of recognition and reparation of victims, not just Abu Zubaydah but other victims? And this strikes me as, I think, one of the most insidious aspects of war on terror practice is the complete refusal to even simply recognise and acknowledge wrongdoing, even with what we know now, which is beyond plausible deniability that these individuals were tortured. We have so much information from official sources, and yet there's an incredible lack of willingness to recognise the wrongdoing, to accept responsibility on the part of states for that, and then indeed to apologise for it. Now, apology perhaps sounds trivial in this context. I'm terribly sorry that we tortured you to within minutes of your life and ruined your life. But apology, I think, is something that's featured increasingly in human rights litigation in this context, where human rights litigators are asking for recognition and apology. And I noticed recently in relation to litigation before the UK courts in relation to individuals who were rendered from Libya, from the UK to Libya in the Belhaj and other cases. In that context, the victims are asking for, instead of the large financial settlements that have been in other contexts, they're asking for £3, one per defendant, one for the man, one for the pregnant woman, and one for the child that were rendered, and an apology. And that's their bid. I don't think there's been any acceptance of that thus far. But the reality is there have, with the exception of Canada and Sweden, I'm not aware of any other apologies having been made to individuals. There have been ex gratia payments that have been made, settlements, but very explicitly without recognition of responsibility. And I think we do have to ask ourselves why that is. And I think the reality is that we do see in this context emerging notions of deserving victims, increasing attention being paid to, quite rightly, to victims of terrorism and victims of crime on the international level. But then there are these other categories of victims, even victims who it's now recognised were simply there because they had, they had the wrong name, the same name as somebody else. They were in the same house as somebody else, they wore the same watch as somebody else, etc. Despite all of that, the refusal to recognise the human being, to seek apology and acknowledgement is, I think, very troubling. It's the antithetical to the notion of the rule of law, I think, in the approach to reparation, and compounds the original wrongs vis-à-vis these individuals. And then turning to the second element, which is criminal accountability. There's only one person, to my knowledge, who's been imprisoned for the rendition-related torture and enforced disappearance crimes. And that was a CIA agent who leaked information in relation to the programme. No one else has been imprisoned. There have, of course, been developments, and those developments are significant, and I think they're certainly very much ongoing. It remains to be seen what will happen. There have been trials in absentia in Italy, obviously imperfect processes, trials in absentia. I was relieved to see you noting that there wouldn't be posthumous, the trials in absentia only go so far, that they don't extend. But really important as well, for all, many of us would object to trials in absentia. The Italian trials in absentia of CIA agents and Italian intelligence agents were extremely important in demonstrating, I think, what was possible in terms of the feasibility that you referred to, Norman, in terms of the feasibility of international investigation and prosecution of these types of crimes. Investigations are open in many other states. In Poland, although the European Court of Human Rights found that the Polish investigation was inadequate, that it wasn't the prompt, thorough, effective and independent investigation that was required under the Convention, we're now looking in the process of implementation of that judgment, how Poland can give effect to that judgment by carrying out such an effective investigation. There are cases open in France, in Germany, in Spain, in Canada last week. Again, the Canadians got it right again, and I believe there are the first charges against a Syrian responsible for the torture of Mararar, the Canadian citizen in Syria, in the context of the rendition programme. So a really important development in that context too. So I think that this area of law and practice is in flux. There are enormous obstacles. It has to be noted in this context, I think, that there has been concerted political pressure that has been put on investigators and prosecutors in this context, and this has been the subject of several international reports, notably from the United States, an excessive politicisation of justice, but also from within the state, pressure being placed that's been referred to, for example, by the European Parliament as an intolerable impediment to the independence of justice. And I think we need to challenge as lawyers and also as academics how we look at those issues, not only shared responsibility for the crimes, but afterwards shared responsibility for the politicisation of justice and impediments that are being posed to criminal justice in response to some of the worst atrocities of the war on terror context. But it is very much a dynamic and ongoing. As you say, it's the snooker game that you referred to earlier. There's very much, I think, a dynamic and ongoing process whereby more and more information comes out. That increases the demand for justice on the national level. There are cases on the international level that provide oversight and, again, create a dynamic and a pressure of sorts, at least an oversight, to ensure that states take their obligations seriously. To wind up just with a few observations on why accountability matters in this particular context from my perspective, and tying back a tiny bit to the book because I feel obliged to do that. I think in the book I tried to highlight a number of characteristics of the war on terror and its relationship with international law. I won't go through those characteristics, but I suggest that they are the antithesis, in a sense, of the rule of law approach to countering terrorism, which is, of course, what the United Nations committed itself to in the UN counter-terrorism strategy. But to take, for example, one of the things that I suggest is that the war on terror has been a massive exercise in exceptionalism, and that exceptionalism in the sense of putting certain people beyond the laws, putting certain places beyond the law, the extraterritorial question, certain states, of course, beyond the law, certain situations beyond the law. And that accountability is, I think, fundamentally about trying to bring that situation back within a rule of law framework in one way or another. And I think what we see from the practice that's emerged, regrettably, are, I think, a number of stark contrasts. I mentioned the tension that arises in respect of the treatment of deserving and undeserving victims. I think we also see it in the approach to criminal law. If we look at the way in which, and Norman referred to this earlier, the way in which criminal law has been treated ever more expansively in the context of prosecuting terrorism, and we contrast that kind of hyperactivity, we might say, in terms of bringing more and more people within the criminal law framework for the purposes of the terrorism label, or indeed people associated with terrorism, people supported of terrorism, acts preparatory to terrorism. This broadening of the web of people who are covered by criminal law in relation to terrorist acts or associated or supportive acts. And that contrasts very starkly with the complete dearth of criminal law responses in relation to war on terror crimes. And I think this contrast poses a real challenge. I think it's dangerous. I think it lends itself to the perception that what we're generating is what I've referred to in the book as a criminal law of the enemy approach to countering terrorism, where the criminal law is used as a tool against those that we wish to have a tool against, but we're not willing, in the context of counter-terrorism, to be accountable to those same standards of criminal responsibility. And I think, finally, accountability is critically about, to paraphrase Obama's phrase about, of course, they're not, Obama has not committed to any investigations on the basis that he wants to look forward and not back. But I think accountability is critically about looking back in order to look forward. It's about learning the lessons from the past, and I think the war on terror gives us many lessons to learn so that we don't simply continue to repeat the same mistakes. I think accountability is about showing that we treat the legal norms, which are about 500 pages of that book, and of course that's only a superficial snippet of it, but it's showing that we take those norms seriously, and that in turn I would suggest is important because it's relevant to insisting on a rule of law approach to counter-terrorism in the future. It's about insisting, the ability to insist on a rule of law approach to countering terrorism by other states around the globe. And finally, I think, and this really is my very final, I think that accountability is, and this is where I'm going to get a little bit human rightsy, because that's my job. I do believe that accountability is about humanisation. Martin Sheenan described the war on terror. Martin Sheenan was the former UN Special Rapporteur on Terrorism and Human Rights. And he described the war on terror and the extraordinary rendition programme in particular as taking us back to a pre-Kantian era. Some people had discussed, are we going back to a pre-charter era, before we had any of these human rights instruments? And he said, no, it's taken us back to a pre-Kantian era where individuals could be reduced to mere means to an end, objects of intelligence value, disposed of when that value was up. And I think across the war on terror, and there are many other examples, we see that dehumanisation, that demonisation of individuals, classifying them into categories wherein we didn't need to respect their fundamental rights. It facilitated somehow those violations. And I think accountability is in a sense about telling the real human stories behind the euphemisms of enemy combatants, of enhanced interrogation techniques, of high value detainees. So thank you very much.
Thanks a lot for these, I think, very, very interesting and also personal presentations which touch upon various topics that we at ASRA but also at ICT work on, the foreign finance issues, the drones, international criminal responsibility in full conformity with international law and human rights. And it was quite interesting to see. While you were giving the presentations, I saw Helen frantically writing, so I think we can soon expect also a third edition of her book. I'm pretty sure that there will be questions. My colleague Wim is there. He has a mic. To whom can I give the floor? Yes, someone there.
Want to do a mic or? Thank you. Hi, my name is Glenn Schoon. I've done work and study off and on in terrorism for roughly 30 years. I was curious, when you look at the accountability factor, sort of two key questions, and I guess it's basically for the two ladies on the panel, although feel free to go in. One is you mentioned with accountability that it's still very fragmented, and internationally at least it's not really seen as a process. I completely agree with you. I'm also completely exasperated by it, because when you look at counterterrorism strategy, normally any management strategy should have a monitoring or audit or review / accountability function in it. And I'm just sort of puzzled, why do you think that's not really there? Because when you look at all other aspects of counterterrorism, any mature counterterrorism policy, whether it's Sri Lanka or Northern Ireland or the US now or the Dutch government, they do have a process function, and normally it should be a key part of that. The other question I had is, do you think when you look at accountability, should we not focus more of our energy on individual governments and states making that accountability work, whether that's through panels such as in Holland with the toezicht on the inlichtingendiensten and that kind of thing, rather than an international issue? You see, I wonder, even for the United States when it makes errors or mistakes, but basically any country in the world, wouldn't you be more effective in unearthing wrongdoing and monitoring things closely to prevent more wrongdoing? Wouldn't that be more effective at the national level if it were strengthened in every country at the national level, if a Polish government had much stronger means to monitor its own services?
Take a few questions and then we'll respond. Yes, Thomas.
I am Thomas Fairfuss, a journalist covering the international courts here in The Hague. I am puzzled, as the previous speaker, about one of the interesting things I learned tonight, namely the Ramstein judgment, which I was not yet familiar with. I wonder by which miraculous mechanism that German court could find that the responsibility of the German state to protect fundamental human rights was just not engaged anymore, because the Federal Republic had surrendered parts of its sovereignty to a foreign country, at least on a certain part of its territory. The Constitution of the Federal Republic contains very strong mechanisms to protect fundamental human rights, amongst other things because of the moment at which it was adopted in 1949, when the horrors of the Second World War were still very fresh in everybody's memory. So the responsibility for the state to protect fundamental human rights in all of its actions is very strongly protected by mechanisms of constitutional law. And it seems like the court found a legal reasoning to justify that the complaint of the Yemeni families was not entertained any further. I think this is a very interesting question, because it is similar to situations we find elsewhere, like in Iraq or Afghanistan, where there may be victims of crimes which have been committed during operations which are part of the war on terror, where it would be very important for those victims to have access to domestic courts when they want to obtain reparations and the satisfaction of seeing of certain perpetrators punished.
Another one, perhaps? Yeah, at the back.
Thank you very much for all the panelists for their presentation. My name is Ziad Ben Masoud. I'm a PhD candidate at University of Paris. I have a question concerning the coherence and of the legal framework concerning the terrorism. Do you think that the co-application of international humanitarian law and international human rights law and the pick and choose strategy of some states between those two corpus juris is contribute to the incoherence of this legal framework? And another question related to the modes of liability. Do you think that if there is a movement into recognizing terrorism as an international crime, is it, I don't know if it is a simplistic solution to apply immediately the mode of liability as recognized in international international criminal law or in the ICC statute immediately to terrorism, and that will solve many problems of the liability and in relation with terrorism? Thank you.
Can I maybe ask Larissa and Helen to respond to the first two questions, and maybe Norm, you can take the third?
Shall I go first? Those are really excellent questions. I'm hoping I can do justice to them and read my own handwriting, which is always one of my problems. In relation to the first question, which I thought was very interesting, in terms of any decent counter-terrorism strategy having this monitoring and audit aspect, I think that's absolutely right that it should have, and it seems that really they don't, right? And either on the international level or, much more importantly, on the domestic level. I may be generalising, of course, to say that they don't, but there's certainly a deficit in that respect. And I agree with you that I think where the emphasis has to be, of course, is on the national level. And certainly even those of us who do international litigation or who try to engage international processes, ultimately at the end of the day what that is about trying to get national processes to do what they're obliged to do and what they're best placed to do, right? So to give you an example, I mean, in Poland, and you referred to this, there are processes underway of reform, for example, looking at what reform needs to happen in terms of the operation of their intelligence agencies, which of course this case shone a light on, and other aspects, I think, in relation to counter-terrorism. But they're political and they're stagnant, and the reform isn't going forward for various reasons, as I understand it. So I think, a small part of what we try to do with an international case like that is to say that the state is obliged to ensure guarantees of non-repetition. They're obliged to look at their own laws as well as the policies and practices that may have facilitated this happening and ensure that they don't happen again. So to some extent it goes together, and we try to use those international processes to impel the much more important national processes, which you're absolutely right about that. Shall I stop on that one, and maybe Larissa could add, or if anyone, Norm?
Yes, thank you. So perhaps I go to the other question on the German case, and perhaps more on state complicity in general. I think what's important, of course, if we look at construction of state complicity, is that you hold a third state responsible, not, I mean, for its action, but indirectly also for the actions of another state. And the question is, how do you make the link between the ultimate action that violated a certain norm and the complicit state? And if we look at the articles on state responsibility on that, we see that it's very difficult to construe that. There must be an essential contribution by the state, or not only a significant contribution, but an essential contribution to the specific act that violated the law. And I think those there must be knowledge that the contribution also was going to result in the violation of international law. So you need really quite high standards, and the mere sharing of intelligence in general does not necessarily create responsibility for states, or the mere fact that you allow your air base in general to be used does not necessarily tie you to a concrete violation. So I think there the standards are quite high, but it might be that we need to revisit, I think, those high standards, and we need to rethink them if you have long-standing policies like the US drone policies, where at some point knowledge can be assumed. So I think there's some openings to perhaps develop and have some maybe lex specialis, even if we don't use this word so much anymore, but applications of the notion of state complicity specifically in the context of counter-terrorism. Sorry. Oh, that's my aim.
Yes.
I've been asked to look at the modes of liability question that was asked by the gentleman at the back. I guess it would be the simplest solution if we could just simply apply the modes of liability from the ICC, and in that sense, I mean, it wouldn't be harder work then to try and figure out what the modes mean in other jurisdictions. I don't know from a different perspective whether or not the application of those modes of liability, I mean, I'm assuming the question involves an assumption that terrorism would be an international crime adopted in the ICC statute, and therefore, as a result, the question is whether the modes of liability under the ICC statute would capture the conduct that essentially has been complained about in terms of terrorism. And by that, you can look at the criminalization of preparatory steps, acts of association, membership, for example. There's a lot of, as Helen points out in her book, there is a lot of ways in which conduct surrounding acts of terrorism have been criminalized. Whether all of them, as Helen points out, set out a certain amount of certainty and recognition that they were crimes at the time they were committed is certainly an issue. The modes of liability under the ICC statute, which I'm not as familiar with anymore, does include acts which are preparatory, planning, or contribution to a common purpose. But of course, there's lots of debate left about what those elements mean, or what they are, including aiding and abetting, which has a purposive element which is contrary to some of the case law of the other jurisprudence, and would mean that you would have to, including those persons that are involved in counter-terrorism acts which are criminal, as Helen and Larissa were addressing, that they would have to be carrying out those acts with the purpose of ensuring the crime was committed, which is a different issue than aiding and abetting the crime with knowledge. So there are some questions about the application of the modes of liability to capture the conduct that is set out as terrorist conduct or criminal conduct in the counter-terrorism effort. I think it would be simpler, though, to limit it somewhat to the modes of liability which have been accepted by states, either at the ICC or indirectly through other means, than to try and expand the modes of liability simply to reflect the crime. That could be maybe a little bit overstepping, I think, which is the premise set forth by Helen in her book.
Maybe on the first question of Mr. Massoud, the pick and choose mentality of states, do you also see that the legal framework is getting more incoherent? Maybe Larissa, you can respond to that.
Well, I think there are several questions in your questions, right? I think there's a pick and choose approach to things, and I think this is what you alluded to with these categories of deserving and undeserving victims, and I think actually your undeserving victims, I would say that Abu Zubaydah is also an undeserving victim, so not only the people who were unlawfully or listed or subjected were undeserving victims, but also people who engaged in terrorism, I think, were undeserving victims, since they did not deserve to be placed out of the law. So I would perhaps even spread the net of undeserving victims wider to include terrorists. I think terrorists, they deserve to be still part of the law in that sense. Then there's another question of coherence, and I think there was also the question of the application of international humanitarian law, human rights law. So that's of course more on the legal, technical level. I think as lawyers we always, of course, strive for coherence. I think there's also merit in incoherence in a sense, or at least, to let as many flowers flourish as we can. And this is what I mean with this notion of multidimensional accountability process, and to foster accountability at the various levels without trying to straitjacket them necessarily. But of course, the substantive law should be to a certain extent coherence. But I think incoherence is also perhaps, a moment of where there's a possibility for progress and development. So I don't think we should be striving too much towards coherence, and perhaps accountability then is a greater value in that quest.
Are there any other questions? Yes, in the back.
Hi, thanks. One question kind of about potential trends or what you all see in the future. The point about dehumanization really struck me, and it made me think about it. There was a time when, combatants of an enemy force maybe weren't seen as someone whose rights need to be protected. Unfortunately, we've come some way in the 19th and 20th centuries to protecting rights and recognizing the humanity of certain actors. Is there a reason for hope? I mean, can you guys identify that in 50 years we may be able to see, perpetrators of terrorism or people at least involved in these kind of crimes in a different light?
Someone else? Maybe following up on that indeed, and Helen, your conclusion was a bit maybe pessimistic, or I should say realistic. Where do you see us going?
Well, at this stage in the process and at this time in night, the last question I want to be asked is do you see any hope? Because it's I'm shaking my head and I'm going to say yes, I do. I see a great deal of reason for hope. Of course I do. I think one thing, I'm not sure this goes to your thoughtful question really, but I think one reason, I think, for great hope, and I think it will come back round to the rehumanisation thing, is the fact that despite, when, again, to go back to the rendition programme, because I'm a little obsessed with it through practice as well as the book now, but that was a programme that was specifically designed to ensure that we never knew about it, and that we never would know about it. And what's been described is not only, something that was designed and orchestrated so as to remove individuals in the programme from oversight, political or legal, but there was also afterwards what's been described by the Council of Europe, for example, as a concerted cover-up to ensure that information never came to light. And there are loads of manifestations of that. And I think the reason for hope is the fact that we do know so much about it. And I think that does tell us that I think, today it is simply... it is impossible. Of course, there's lots of individuals who are still unaccounted for. So that, in a sense, Abu Zubaydah is not the worst news story. There are still individuals unaccounted for. But the fact is that we do know so much, and we know so much about the individuals who've gone into this programme, and so much information comes out about the programme and about their stories, and that inevitably, I think, has a rehumanising value, right? The power of individuals. And however much there's now this ban on saying anything about him, but still little bits will come out, So in that sense, I think the reason for hope is that complete impunity, even in respect of information, I think is simply no longer possible today in a way that it would have been in the past. And I think we just have to build on that to try to move towards justice. So is that as hopeful as I can get at 8 o'clock? I don't know if others... Thank you.
Any other questions? Otherwise, this is a very nice way, actually, of concluding the evening. Yes, let's do that. So thank you very much for your excellent questions and answers. I think it was a very interesting evening. I'm sure it has inspired many people in the room.